What issues can cause problems or delays for the sale of probate real estate at a court confirmation hearing? What we're talking about here is probate real estate limited authority disaster. Welcome back to the channel. I'm Brendan Moore, California Realtor and Certified Probate and Trust Specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed professional fiduciary, a licensed California real estate broker, as well as a registered and bonded California legal document assistant specializing in probate.
Please like this video, subscribe to our channel. Want your probate done for no fee? Every day we help people save thousands of dollars and eliminate headaches with our one-of-a-kind probate administration service and real estate listing combo in California. Please reach out to us with any questions. Comment on this video. Our contact information is below. Email, call, text, because we can help you. All right, Bill, let's talk about this. There's a lot of things that can happen at a court confirmation hearing or leading up to one that can cause absolute disaster for a sale that required court confirmation, one in limited authority.
Absolutely, and I have a little list here of bombshells that can go off at the hearing, which can cause problems.
I bet that's not even a complete list, to be honest.
It's not complete, but it's some of the major ones. One of them, which you and I have experienced, is a change in the terms of the sale between the time the petition to obtain the order confirming the sale, between the time that's filed with the court and the hearing date. Sometimes what happens is, for whatever reason, the buyer wants to renegotiate or change something between those times. And if you get to the hearing date and tell the court that the terms have changed, and they're going to continue the hearing out to another date, and that's going to delay the sale probably by at least 30 days, maybe even 90 days.
Yeah, and that's typically because they did inspections and they found some sort of issue, but they didn't do it in a timely manner.
Correct.
And unfortunately, that's when you're dealing with probably the buyer's agent who didn't understand probate well enough to understand what it was that they were doing and the big mistake that they were doing, regardless of how much guidance I could give them on my side. If you're a buyer's agent or you're buying probate property and it's going to go through a court confirmation hearing, which is the lesser common, limited authority isn't as common as full authority, but if it is going through a limited authority, you don't want to change that contract very much at all after the first 10 days or so.
Yeah, you really what you want to have is, at the time you file that petition to get the hearing date to confirm the sale, you want to have everything locked down at that point. You don't want changes after that, because it can cause delays.
What's your next one?
Well, the next one on my list is the failure of the administrator and or probate professional, be it the attorney or be it myself, although fortunately I've never done this, is to properly publish the notice of sale in the newspaper prior to the hearing. The probate rule requires that in a court confirmation hearing, you have to publish the notice of sale out there to give notice to everybody in the world that they wanted to, they could come into the court and bid on that property, bid a higher price. And what's interesting about the notice of sale is most newspapers have no template for that. For other publications in probate, they have a template, which makes it easy, but the administrator or the attorney or the probate professional, whoever's doing the probate, you basically have to write up that notice of sale from scratch, and you got to make sure it meets the court standards, because if it doesn't, and you get to that hearing date, the court's going to say, sorry, and they're going to delay it out to another hearing and tell you to go republish the notice of sale. So I have seen that happen a number of times.
That's one of those things that if you're a pro-per, somebody doing it yourself in probate, just one of the many, many, many things that makes it so difficult.
Let's see, next on my list is the failure to give all interested parties notice of the court confirmation hearing date. What a lot of people who are doing probate, whether it's yourself, most attorneys, probate attorneys know this, but a lot of non-attorneys that do probates don't know all this. You have to make sure that you give everybody notice of the hearing date, proper notice that the court requires. And that includes the buyer's agent the seller's agent, the buyer themselves, the seller themselves, in addition to any heirs to the estate, as well as if there were any what are called requests for special notices filed with the court. So you got to make sure that's all done. And if it's not, again, you're going to get to that hearing date and the court's going to say, continue it out, delay. So that's another one that it gets missed, especially by people trying to do probates themselves.
I always think it's kind of funny because I see you all the time, but whenever we have one that's in limited authority, I receive a piece of mail from you, a big fat envelope, full of these documents. I'm like, I already have these documents, Bill, but you're required to send
have to do it. Have to do it.
Yep. What's another one?
Well, the next one, which is kind of interesting, and we've talked about this a little bit in some of our other videos that deal with the probate referee, who's the court's appraiser. What happens sometimes is if it's been more than 1 year from the time the decedent passed on to the court hearing date, you have to go back to the probate referee and get what's called a reappraisal for sale. That's essentially another appraisal by the probate referee, because he already did one for when on the date of death, but now you got to get one for this hearing. And a lot of people forget to do that, especially pro-pers. I've even seen some attorneys miss this because they don't always check the date of death and say, oh, has it been a year? It doesn't always happen. But again, if you get to the hearing date, you haven't done that reappraisal for sale when it's required, continuation, another hearing date. And to tie in something to that is if the contract price is not within 90% of that reappraisal for sale price, the court's likely not going to let it go through. It'll be a decision that the judge will have to make. I have seen rare occasions where the judge lets it go as long as he's got all the heirs there and they all agree. But technically, they're not supposed to. So that can cause a problem. Yeah.
What else would be a significant?
Well, the last one, significant one I have on my list, this one I want to kind of talk about walking a line on this one, and I'll tell you why. You'll hear that a buyer coming into a court confirmation sale has to have a 10% deposit, okay? Well, you and I both know from experience that that's not always the case. We've had buyers come in with less than 10% and it's gone through. Most of the time you'll be okay with less than 10%, but there are some courts. Each court is a little different on how they handle things. But there are some courts out there, there's 52 counties in California, I think.
That's about right.
Yeah. So you got 52 superior courts, probate courts. There are some courts that'll have, a judge or a local rule hard and fast says, nope, we want 10%. And if you happen to be doing a court confirmation hearing in that county and you've got a judge that's going to adhere to that, and you don't have a 10% down buyer, again, it may not go through.
Yeah, there's a little bit of a fine line one. You definitely want to check with court, contact the court clerk, I suppose.
Yeah, and check their local rules. That's very important. The other thing you can do is you can go back and look at past cases, court confirmation hearings, and look at the documentation and see how that went. That's helpful.
Alternatively, we have done several in certain counties, some very large counties in California, where maybe an FHA buyer, and FHA buyers are usually putting down 3.5%, sometimes even less. Yeah. They don't have 10% of the purchase price.
Yeah.
It's gone through just fine. It was what was best for the estate. It was the highest offer, the most proceeds. The deposit really at that point, it's not extra money for the estate.
And also, Brendan, just as a realtor, that specializing in probate, don't you think, or wouldn't it be something that if you put as a requirement that a buyer has to come in with 10%, aren't you gonna eliminate a pretty big pool of buyers?
You absolutely would. If it's something where it's a property in the condition where it can be financed on. That's not a serious fixer.
Yeah.
But most homes, if it's a move-in ready home, doesn't necessarily mean it's updated or something like that. But yeah, most of the time, if it's something where you're looking for a family to move in kind of thing, or a single person, whatever, it's going to be their primary residence, they want to move right in. Yeah, if it's a 10% deposit requirement, you're eliminating. There's people out there with 5% conventional loans, 3.5% FHA, VA, where they're putting no down. Now you just eliminate all the veterans. So that eliminates a large buying pool. You're probably not going to get the best offer.
Yeah, and to me, it would seem it's not in the best interest of the estate to eliminate those potential buyers from that probate sale.
You want to open it up as much as possible.
Yeah.
What I've often found is VA buyers, because it can be a little bit more complicated for them to get their offer accepted. A lot of people don't want to, because a lot of maybe misconceptions about VA loans, and they're putting no money down a lot of the time. They tend to put in the highest offers. Now you can't have one.
Yeah.
But of course, you got to put down some deposit, and they usually do. Well, that's all great information. One thing you don't want to ever do at a court confirmation hearing that I have seen, that's not the time to show up as an heir or something and try to ask questions to the judge. The judge will not be happy about that.
Yeah.
And you might find the bailiff escorting you out of the room. We have seen that. Anything else you'd like to add?
I think those are some of the major bombshells that could go off at a court confirmation hearing. So I think that covers it for now.
So that's all great information. And I think that what our audience really needs is to really learn the difference between limited authority and full authority. And we have a great video on that. It's actually called Limited Authority versus Full Authority. One of our very first videos we put on our channel, and it's going to appear right above his head right now. Click on it, hurry.